Connecticut State Department of Education. Connecticut State Department of Education Bureau of Special Education. March 2021. Procedural Safeguards Notice required under IDEA Part B. Connecticut State Department of Education Bureau of Special Education. Revised March 31st, 2021. The Connecticut State Department of Education is committed to a policy of equal opportunity affirmative action for all qualified persons. The Connecticut State Department of Education does not discriminate in any employment practice, education program, or educational activity on the basis of age, ancestry, color, civil air patrol status, criminal record in state employment and licensing, gender identity or expression, genetic information, intellectual disability, learning disability, marital status, mental disability, past or present, national origin, physical disability, including blindness, race, religious creed, retaliation for previously opposed discrimination or coercion, sex, pregnancy or sexual harassment, sexual orientation, veteran status or workplace hazards to reproductive systems, unless there is a bona fide occupational qualification excluding persons in any of the aforementioned protected classes. Inquiries regarding the Connecticut State Department of Education's non-discrimination policies should be directed to Levy Gillespie, Equal Employment Opportunity Director, Americans with Disabilities Act, ADA Coordinator. Connecticut State Department of Education, 450 Columbus Boulevard, Suite 505, Hartford, CT 06103-2071, levy.gillespie@ct.gov. Contents Independent Educational Evaluation, IEE, Confidentiality of Information, Access to RECOM, State Complaint Procedures, Point 0, Due Process Procedures, Resolution Process, Mediation Advisory Opinion Process, Hearing Decisions, 0 Appeal, Point 0, Rule of Construction. The child's placement, while the due process hearing is pending. Attorney's fees or procedures for disciplining children with disabilities. Protections for children not yet eligible for special education and related services. Referral to and action by law enforcement and judicial authorities. 00.00 Requirements for unilateral placement by parents of children in private schools. Procedural safeguards required under IDEA Part B, Introduction. The Individuals with Disabilities Education Improvement Act, IDEA, the federal law concerning the education of students with disabilities, requires schools to provide you, the parent, with a notice containing a full explanation of the procedural safeguards available under the IDEA and the regulations implementing the IDEA. A copy of this notice must be given to you one time each year, and when the following occurs: the first time you or the school district asks for an evaluation, you ask for a copy of these procedural safeguards. The first time in a school year, you request a due process hearing or file a state complaint. A decision is made to take a disciplinary action against your child that is a change in placement. The procedural safeguards notice must include a full explanation of all of the procedural safeguards available under the regulations implementing the IDEA, which are the following: 34 CFR 300.148. Unilateral placement, 34 CFR 300.151, 34 CFR 300.152, and 34 CFR 300.153. State complaint procedures, 34 CFR 300.9 and 34 CFR paragraph 300.300. Parental consent, 34 CFR 300.502. Independent educational evaluation, 30 CER 300.503. Prior written notice, 34 CFR 300.505 through 34 CFR 300.518. Other procedural safeguards, mediation, resolution process, impartial due process hearing, 34 CFR 300.530 through 34 536. Discipline procedures, 34 CR 334 CFR 300.625. Confidentiality of information. Each section has the federal citation printed with it. Where there is a state statutory or state regulatory provision that coincides with the federal requirements, the state citation is provided. If you have any questions regarding this document, you can contact the Bureau of Special Education, Connecticut State Department of Education Bureau of Special Education, P.O. Box 2219 Hartford, CT 06145-2219. Tel 860-713-6910. Connecticut State Department of Education, Procedural safeguards notice required under IDEA Part B General Information. Definition of school district. As used in this document, school district means a local or regional board of education. The Connecticut Technical Education and Career System. The school districts operated by the Department of Correction and the Department of Children and Families and the Department of Mental Health and Addiction Services in the provision of regular and special education to eligible clients. Prior written notice 34 CFR 300.503, Regulations of Connecticut State Agencies, RCSA 1076 DAA. You have the right to receive written notice no later than 10 school days before the Planning and Placement Team, PPT, proposes to or refuses to initiate or change the identification, evaluation, or educational placement of your child, or the provision of a free, appropriate public education to your child. This is called prior written notice. Content of notice. The written notice must tell you exactly what the school district proposes or refuses to do, why the school district proposes or refuses to take action, the other options the PPT talked about, and the reasons why those were not done, about each evaluation procedure, assessment, record, or report that the PPT used as a basis for the proposed or refused action, about other factors that were relevant to the PPT's proposal or refusal, that you have protections under the procedural safeguard provisions of the IDEA, how you can get a copy of these procedural safeguard protections, and resources for you to contact to get help in understanding the IDEA as it relates to the provision of special education and related services for your child. Notice in understandable language. The notice must be written in a way that would be easy to read and understand and provided in your native language or another mode of communication, unless it is clearly not possible to do so. If your native language or other means of communication is not a written language, the school district must make sure the notice is given orally or by another way to you. You understand what is in the notice, and there is written evidence that these two steps have been taken. Connecticut State Department of Education, 2 Procedural Safeguards Notice required under IDEA Part B Electronic Mail, 34 CFR 300.505. You may choose to receive the following documents by email if this option is available in your school district: prior written notice, procedural safeguards notice, and notices related to a due process hearing. Connecticut State Department of Education, Procedural Safeguards Notice required under IDEA Part B, Parental Consent. Definition 34 CFR 300.9. Consent means 1. You have been fully informed in your native language or another mode of communication about the action for which you are being asked to give consent. You understand and agree in writing to let the school district take the action for which they are asking your consent. The consent describes this action, and if school records are to be sent to someone, the school district tells you what records will be sent and to whom the records will be sent. You understand that you willingly give consent, and you may withdraw your consent at any time. If you wish to withdraw your consent, you must do so in writing. If the school district requests consent and you do not respond to the school district in 10 school days, the school district will take that to mean that you do not give your consent. If you withdraw your consent, the withdrawal does not affect the actions taken or the services provided to your child during the time the school district had your consent. The school district is also not required to change your child's education records to remove any reference that your child received special education and related services after you withdraw your consent. When a child turns 18 years old, the child has all rights the parent used to have. A child will not get these rights if the court has said the child is not able to decide in a way that is good for the child. The school district shall give any notice required by law to both the child and the parent, even though the child would now have the rights that the parent used to have. When the rights pass from the parent to the child, the school district must notify the child and the parent of the transfer of rights. Connecticut State Department of Education Procedural Safeguards Notice required under IDEA Part B Parental Consent 4 CFR 300.300. RCSA Paragraph 1076D-8. Consent for initial evaluation. 34 CFR 300.300. An initial evaluation, testing, is done to find out if a child is a child with a disability and the kind and amount of special education services a child needs. Your school district cannot conduct an initial evaluation of your child to determine whether your child is eligible for special education and related services without first providing you with prior written notice of the proposed evaluation and obtaining your consent as described above. Your consent for the initial evaluation does not mean that you have also given your consent for the school district to start providing special education and related services to your child. Failure to respond to a request from the school district for consent to conduct an initial evaluation, reevaluation, or for the initial receipt of special education and related services within 10 days from the date of the notice to you will be interpreted as a refusal to consent. If your child is enrolled in public school, or you are seeking to enroll your child in a public school, and you have refused to provide consent or failed to respond to a request to provide consent for the initial evaluation of your child, your school district may, but is not required to, seek to conduct an initial evaluation of your child by using the IDEA's mediation or impartial due process hearing procedures. Your school district will not violate its obligations to locate, identify, and evaluate your child if it does not pursue an evaluation of your child in these circumstances. Special rules for initial evaluation of wards of the state. When a school district seeks to evaluate a student for the first time, and the student is in the custody of the Commissioner of the Department of Children and Families and is not residing with the student's parents, the school district is not required to get the consent from the parent to determine whether the student has a disability and is in need of special education services if 1. After reasonable efforts, the school district cannot find out where the parent is located. The rights of the parent have been terminated by the court. Or 3. A judge decided that the rights of the parent to make decisions about the child's education is to be made by a person appointed by the court. In such situations, the surrogate parent would give consent for evaluation. Consent for initial receipt of services. Your school district must obtain your informed consent before providing special education and related services to your child for the first time. If you fail to respond or refuse to give consent for your child to receive special education and related services, or if you later withdraw your consent for your child to receive special education and related services in writing, your school district may not use the Connecticut State Department of Education 5 Procedural Safeguards Notice required under IDA Part B, Procedural Safeguards, mediation or due process hearing, to reach an agreement or get a ruling that services may be provided to your child without your consent. Under these circumstances, the school district would not violate its responsibility to make FAPE available to your child and is not required to hold a PPT meeting or develop an individualized education program, IEP, for your child. If you withdraw your consent in writing at any point after your child is first provided special education and related services, then the school district may not continue to provide such services, but must provide you with prior written notice before stopping the services. Consent for reevaluations. Your school district must obtain your written consent before it reevaluates your child. If you do not respond to a request from the school district for consent to reevaluate your child within 10 school days from the date of the notice to you, your failure to respond will be interpreted as a refusal to consent to the reevaluation. Documentation of reasonable efforts to obtain parental consent. Anytime the school district seeks your consent, the school district must have a record of its reasonable efforts to get your permission. This record may include telephone calls tried or made and the results of those calls, and copies of letters sent to you and any letters you send back to the school district. Other consent requirements. Your consent is not needed before the school district reviews existing records of your child that the school district already has when the school district is evaluating or reevaluating your child, gives a test or other means of evaluation that is given to all children unless the school district gets permission from all parents before giving a test or other means of evaluation, or places your child in a private school. If the school district files for a due process hearing, see due process procedures, to determine whether it may conduct an evaluation of your child, and the hearing officer decides in favor of the school district may evaluate your child without your consent. If you disagree with the hearing officer's decision, you may go to either the state superior court or the federal district court to stop the school district from evaluating your child. If you disagree with a decision to place your child in a private school, you may file for a due process hearing to determine the appropriate placement, or you may withdraw consent for the provision of all special education and related services to your child. Connecticut State Department of Education. 6. Procedural safeguards notice required under IDEA Part B Independent Educational Evaluation, IEE, 34 CFR 300.502, RCSA 1010-76D9 General. If you disagree with an evaluation that a school district has obtained, you have the right to request the school district pay for an evaluation conducted by an examiner who is not employed by the school district. This is called an Independent Educational Evaluation, IEE, done at public expense. You must disagree with the evaluation of your child obtained by the school district to be able to request an IEE at public expense. Public expense means that the school district either pays for the full cost of the IEE or ensures that the evaluation is otherwise provided at no cost to you. The school district may ask you for the reason you object to the evaluation obtained by the school district. You are not required to explain why you disagree with the evaluation obtained by the school district. The school district may not require an explanation and may not unreasonably delay either providing the IEE at public expense or filing for a due process hearing to defend the school district's evaluation of your child. If you request an IEE at public expense, the school district must provide you with information about where you may obtain an IEE and about the school district's criteria that apply to independent educational evaluations. Right to an IEE at public expense. You have the right to an independent educational evaluation of your child at public expense if you disagree with an evaluation of your child obtained by the school district subject to the following conditions. 1. If you request an IE of your child at public expense, your school district must, without unnecessary delay, either A. Request a due process hearing to show that its evaluation of your child is appropriate, or that the independent evaluation did not meet the school district's criteria, or B. Provide an IE at public expense. 2. If the hearing officer decides that the school district's evaluation is appropriate, then the school district does not have to pay for the evaluation requested or arranged for by you. However, you still have the right to have an IEE done at your own expense. 3. You are entitled to only one IEE at school district expense each time the school district conducts an evaluation with which you disagree. Parent-initiated IEEs. You have the right to obtain an IEE at your own expense. You may give the results of the evaluation to the school district. If you share the results of the evaluation with the school district must consider the results of the evaluation if it meets the school district's criteria for IEEs in any decision made with respect to the provision of FAPE to your child, and the evaluation results may be used at a due process hearing. Connecticut State Department of Education. 7. Procedural safeguards notice required under IDEA Part B requests for evaluations by hearing officers. A hearing officer may order that a child receive an IEE. The school district must pay for this evaluation. School district criteria. When the school district pays for an IEE, the evaluation must meet the standards for evaluation used by the school district. This includes the location where the evaluation is done and the skills of the person doing the evaluation. The school district may not set additional standards or timelines for IEEs at public expense. The standards of the school district must not interfere with your right to obtain an IEE at public expense. Connecticut State Department of Education. 8. Procedural safeguards notice required under IDEA Part B, Confidentiality of Information Definitions, 34 CFR Parag 300.611. As used under the heading, Confidentiality of Information, destruction means physical destruction or removal of personal identifiers from information so that the information is no longer personally identifiable. Education records means the type of records covered under the definition of education record in 34 CFR Part 99. The regulations implementing the Family Educational Rights and Privacy Act, FERPA, of 1974, 20 U.S.C. 1232G. D. Personally identifiable. 34 CFR 300.32 means information that includes your child's name, your name as the parent, or the name of another family member, your child's address, a personal identifier, such as your child's social security number or student number, or a list of personal characteristics or other information that would make it possible to identify your child with reasonable clarity. Notice to parents, 34 CFR 300.612. Your state must give you notice that is adequate to fully inform you about confidentiality of personally identifiable information, including 1. A description of the extent to which the notice is given in the native languages of the various population groups in the state. A description of the children on whom personally identifiable information is maintained. The types of information sought, the methods the state intends to use in gathering the information, including the sources from whom information is gathered, and the uses to be made of the information. 2. A summary of the policies and procedures that participating agencies must follow regarding storage, disclosure to third parties, retention, and destruction of personally identifiable information. 3. A description of all the rights of parents and children regarding this information, including the rights under FERPA. Before any major activity to identify, locate, or evaluate children in need of special education and related services, also known as child find, 34 CFR 300.11, the notice must be published or announced in newspapers or other media, or both, with circulation adequate to notify parents. Connecticut State Department of Education 9 Procedural Safeguards Notice required under IDA Part B, Access to Records, Access Rights, 34 CFR 300.613, RSCA 1076-18. You must be allowed by the school district to inspect and review all education records kept or used by the school district that are collected, maintained, or used by your school district under Part B of the IDEA. This means you have the right to review and inspect all education records concerning the identification of your child as a child eligible for special education, evaluation of your child to determine eligibility for special education, the educational placement of your child, or your child's right to FAPE when your request is in writing. Section 10-76D18 of the Regulations of Connecticut State Agencies requires that your school district allow you to inspect educational records no later than 10 school days after you request to do so. If you make a request to review and inspect your child's educational records when school is not in session, the school district must make the records available for inspection within a reasonable period of time, but no more than 45 calendar days after it has received your request. This is a requirement under FERPA, which school districts are obligated to follow, even though there is a different state standard based on school days. The school district must, in spite of the timelines noted above, comply with your request without unnecessary delay and before any PPT meeting, resolution meeting, or hearing, including a hearing about discipline. Your right to inspect and review your child's education records includes 1. Your right to get a response from the school district to your reasonable requests for explanations and interpretations of the records. 2. Your right to receive one free copy of the records. This is a right guaranteed by Section 1076D18 of the Regulations of Connecticut State Agencies. You must ask for a free copy in writing. The school district has 10 school days to provide you with a copy of the records. The school district may charge for additional copies. However, the school district may not charge you for the additional copies if doing so would interfere with your right to review and inspect your child's records. 3. Your right to have a person acting for you inspect and review the records. Record of Access 34 CFR 300.614. Each school district must keep a record of the parties obtaining access to education records collected, maintained, or used under Part B of the IDEA, except access by parents and authorized employees of the school district, including the name of the party, the date access was given, and the purpose for which the party is authorized to use the records. Connecticut State Department of Education. 10 procedural safeguards notice required under IDA Part B, records on more than one child. 34 CFR 300.615. If any education records include information on more than one child, the parents of those children have the right to inspect and review only the information relating to their child, or to be informed of that specific information relating to their child. List of types and locations of information 34 CFR Carry 300.616. On request, your school district must provide you with a list of the types and locations of education records collected, maintained, or used by the district. Fees 34 CFR 300.617. The school district may not charge a fee to look for records. Amendment of records at parents' request 34 CFR 300.618. If you believe that information in the education records regarding your child collected, maintained, or used under Part B of the IDEA is inaccurate, misleading, or violates the privacy or other rights of your child, you may request that the school district change the records. The school district must decide whether to change the information in accordance with your request within a reasonable period of time of receipt of your request. If the school district refuses to change the information as you have requested, the school district must inform you of this refusal and advise you of your right to a hearing to challenge the content of the record. See below. Challenging the content of the record, opportunity for a hearing, 34 CFR 300.619. The school district must, on request, provide you with an opportunity for a hearing to challenge the content of your child's education records to ensure that it is not inaccurate, misleading, or otherwise in violation of the privacy or other rights of your child. Hearing procedures 34 CFR 300.621, 34 CFR 99.22. A hearing to challenge information in your child's education records must be conducted according to the procedures for this hearing found in FERPA. Connecticut State Department of Education 11 Procedural Safeguards Notice required under IDA Part B. Result of hearing 34 CFR 300.622, 34 CFR 99.21. If, as a result of the hearing, the school district decides that the information is inaccurate, misleading, or otherwise in violation of the privacy or other rights of your child, it must change the information accordingly and inform you in writing. If, as a result of the hearing, the school district decides that the information is not inaccurate, misleading, or otherwise in violation of the privacy or other rights of your child, it must inform you of your right to place in the records that it maintains on your child a statement commenting on the information or providing any reasons you disagree with the decision of the school district. The explanation placed in the records of your child must be maintained by the school district as part of the records of your child, as long as the record or contested portion is maintained by the school district. If the school district discloses the records of your child or the challenged information to any party, the explanation must also be disclosed to that party. Consent for disclosure of personally identifiable information. 34 CFR 300.622. 34 CFR 99.31a2. Unless the information is contained in education records and the disclosure is authorized without your consent under FERPA, your consent must be obtained before personally identifiable information is disclosed to parties other than officials of other agencies that participate in Part B of the IDEA. Except under the circumstances described below, your consent is not required before personally identifiable information is released to officials of other agencies that participate in Part B of the IDEA for purposes of meeting a requirement of Part B of the IDEA. Your consent or consent of an eligible child who has reached the age of majority under state law must be obtained before personally identifiable information is released to officials of other agencies that participate in Part B of the IDEA, providing or paying for transition services. Your school district is permitted to disclose information from your child's education record to another school without your consent. When you seek to, or intend to, enroll your child in another school, district, or post-secondary school, the school district must make a reasonable attempt to notify you in advance of the disclosure. Safeguards 34 CFR 300.623. Each school district must protect the confidentiality of personally identifiable information at collection, storage, disclosure, and destruction stages. One official at each school district must assume responsibility for ensuring the confidentiality of any personally identifiable information. Connecticut State Department of Education, 12 Procedural Safeguards Notice Required under IDEA Part B. All persons collecting or using personally identifiable information must receive training or instruction regarding the state's policies and procedures regarding confidentiality under Part B of the IDEA and FERPA. Each school district must maintain for public inspection a current listing of the names and positions of those employees who may have access to personally identifiable information. Destruction of information, 34 CFR Car 300.624, CT State Library Records Retention Schedule. Your school district must inform you when personally identifiable information collected, maintained, or used under Part B of the IDEA is no longer needed to provide educational services to your child. In Connecticut, school districts are required to maintain special education records for 6 years after the records are no longer needed to provide educational services to your child, i.e., graduation, exiting from special education, and transfer to another school district or private school. After this time period has elapsed, the school district must destroy your child's information if you request them to do so. A permanent record of your child's name, address, phone number, his or her grades, attendance records, classes attended, grade level completed, and year completed may be maintained without time limitation. Connecticut State Department of Education, 13 Procedural Safeguards Notice Required under IDEA Part B, State Complaint Procedures. Differences between state administrative complaints and due process hearings. The regulations for Part B of the IDEA have different procedures for state administrative complaints and for due process hearings. As explained in greater detail below, any individual or organization may file a state complaint alleging a violation of any Part B requirement or any state statute or regulation relating to the provision of special education to eligible children by a school district, the Connecticut State Department of Education, CSDE, or any other public agency responsible for providing services under state statutes or regulations regarding the provision of special education and related services. Only you or a school district may file for a due process hearing on any matter relating to a proposal or a refusal to initiate or change the identification, evaluation, or educational placement of a child with a disability or the provision of FAPE to the child. An investigation of a state administrative complaint must be completed within a 60 calendar day timeline unless the timeline is properly extended. An impartial hearing officer must conduct a due process hearing, if not resolved through a resolution meeting or through mediation, and issue a written decision within 45 calendar days after the end of the resolution period, unless the hearing officer grants a specific extension of the timeline at your request or the school district's request. The state administrative complaint and due process resolution and hearing procedures are described more fully below. The CSDE has developed model forms to help you file for a due process hearing and help you or other parties to file a state complaint. You may access this information and forms on the CSDE website at the Bureau of Special Education's Legal and Due Process page. State Administrative Complaint Procedures, 34 CFR 300.151, General. The CSDE has a written procedure for resolving any complaint, including a complaint filed by an organization or an individual from another state, and has a procedure for the filing of a complaint with the CSDE. The state complaint procedures are available on the CSDE website, as indicated at the Bureau of Special Education's Legal and Due Process page. If in its investigation of the complaint, the CSDE finds that a school district has failed to provide appropriate services, the CSDE must address 1. The failure of the school district to provide appropriate services, including corrective action appropriate to address the needs of the child, such as compensatory services or monetary reimbursement. 2. Appropriate future provision of services for all children with disabilities. Connecticut State Department of Education, 14 Procedural Safeguards Notice Required under IDEA Part B State Complaint Procedures, Time Extension, Final Decision, Implementation 34 CFR Paragraph 300.152. The CSDE shall make and issue a decision about the issues in the complaint within 60 calendar days after the complaint is filed with the CSDE. The 60 calendar day limit may be extended if CSDE believes there are exceptional circumstances with respect to this complaint, or complainant and the school district agree to extend the timeline while they pursue mediation. In making a decision, the CSDE shall carry out an on-site visit as appropriate if the CSDE believes it must be done. 2. Give the complainant a chance to give, orally or in writing, more facts about the complaint. 3. Provide the school district with the opportunity to respond to the complaint, which may include a. If the school district so desires, a proposal to resolve the complaint, and b. An opportunity for the complainant and the school district to go to mediation. 4. Review all relevant information regarding the complaint and decide if the school district violated a requirement of either state or federal special education law. 5. Send out a written decision to the complainant. The decision will address each issue raised in the complaint and contain the facts on which the decision was based, how the facts were related to the decision, and the reasons for the decision. 6. Carry out other activities that may be appropriate to the investigation. 7. Include procedures for effective implementation of the decision if needed, including a. Assistance to the school district by the CSDE, b. Negotiations, and c. Corrective actions for the school district to take to meet the requirements of law. State complaints and due process hearings. You may also request a hearing even if a complaint has been filed. However, the CSDE will not look into any part of a complaint that is also part of the due process hearing until the final decision of the hearing is made. Any issue in the complaint that is not part of the due process hearing must be resolved following the steps above in this section. If an issue is raised in a complaint that was already decided in a due process hearing with you and the school district, the hearing decision is final and will not be reviewed by the CSDE. The CSDE will inform the person who files the complaint that a review will not be done. If a complaint states that the school district has failed to carry out the final decision of the due process hearing, the CSDE shall resolve the complaint. Filing a state administrative complaint. 34 CFR 300.153. The complaint must claim a violation that occurred not more than 1 year before the date that the complaint is received. The complaint must be made in writing and signed. The person or organization filing the complaint is called the complainant. Connecticut State Department of Education 15 Procedural Safeguards Notice Required. Under IDEA Part B, the complaint must state 1. The school district or the CSDE or any other public agency that is responsible for providing services under Part B of the IDEA or state statutes or regulations regarding the provision of special education and related services did not carry out the federal IDEA or special education laws. 2. The facts on which the complaint is based. 3. The signature and contact information for the person or organization filing the complaint. If the complaint involves a specific child, the complaint shall include the name and address of the child. 2. The name of the school the child is attending. 3. In the case of a homeless child, the available contact information for the child and the name of the school the child is attending. 4. A description of the nature of the problem of the child, including the facts related to the problem. 5. A proposed resolution of the problem to the extent known and available to the complainant at the time the complaint is filed. The person or organization filing the complaint must send a copy of the complaint to the school district against whom the complaint is filed at the same time the complaint is filed with the CSDE. The mailing address for the CSDE is Connecticut State Department of Education Bureau of Special Education, Due Process Unit P.O. Box 2219 Hartford CT 0615-22 Fax 860-713-7153. The complaint may also be submitted electronically to dueprocess.sde@ct.gov. A model state complaint form is available on the CSDE website. It is not required that this form be used to file a complaint. However, note that the information listed in the form is the information that must be provided when a complaint is filed with the CSDE. Connecticut State Department of Education. 16. Procedural safeguards notice required under IDEA Part B due process. Procedures General 34 CFR 300.507 and 34 CFR Bar 300.511. Connecticut General Statutes, CGS, FR 1076H. RCSA FR 1076H-1 through 1076H-18. You or the school district may file for a due process hearing on any matter relating to a proposal or refusal to initiate or change the identification of a child, the evaluation of a child, the educational placement of a child, or the provision of FAPE to a child. Filing for a due process hearing begins the Special Education Administrative Hearing process. You may hear the hearing process referred to as an impartial hearing, special education hearing, or due process hearing. The due process hearing request must allege a violation that happened not more than 2 years before you or the school district knew or should have known about the alleged action that forms the basis of the due process hearing. This 2-year limitation does not apply to you if you could not file for a due process hearing within the timeline because the school district specifically misrepresented that it had resolved the issues identified in the hearing request, or the school district withheld information from you that it was required to provide to you under Part B of the IDEA. For example, if you were not given a copy of this document, Procedural Safeguards Notice required under IDEA Part B, the 2-year limitation will start at the time a copy is properly given to you. Information for parents. The school district must inform you of any free or low-cost legal and other relevant services available in the area if you request the information, or if you or the school district file for a due process hearing. When you ask for a due process hearing, the school district will tell you about the use of mediation as a means to settle the issues. Filing for a due process hearing. 34 CFR 300.508, CGS Brass 1076, RCSA 10-76H1 through 1076H-18. In order to request a due process hearing, you or the school district or your attorney or the school district's attorney must submit a due process hearing request to the other party. As indicated above, submitting a due process hearing request means the same thing as requesting a hearing. The due process hearing request must contain all of the following information and must be kept confidential. Connecticut State Department of Education. 17 Procedural Safeguards Notice required under IDEA Part B. The due process hearing request must contain the following information: the child's name, the address of the child's residence. If the child is homeless, the available contact information for the child. A description of the nature of the problem relating to the proposed or refused action, including the facts related to the problem. 5. What will resolve the problem to the extent known and available to the complaining party, you or the school district, at the time. 6. The name of the child's school. You or the school district may not have a due process hearing until you or the school district or your attorney or the school district's attorney files a due process hearing request that includes the information listed above. Whoever files the hearing request must also provide the CSDE with a copy of the request. Send the copy to Connecticut State Department of Education, Bureau of Special Education, Due Process Unit, P.O. Box 2219, Hartford, CT 061452219. Fax 860-713-7153. The request for a due process hearing may also be submitted electronically to dueprocess.sde@ct.gov. Sufficiency of hearing request. For a due process hearing to go forward, it must be considered sufficient. The due process hearing request will be considered sufficient if it has the information listed above, unless the party receiving the due process hearing request, you or the school district, notifies the hearing officer and the other party in writing within 15 calendar days of receiving the request that the receiving party believes the due process hearing request does not contain the required information. The hearing officer, within 5 calendar days of receiving this notice, must decide if the required information has been given and immediately notify you and the school district in writing of that decision. If the receiving party does not notify the hearing officer, the request for hearing would be considered to contain the required information. Amending the due process hearing request. You or the school district may make changes to the due process hearing request only if the other party approves the changes in writing and is given the chance to resolve the dispute through a resolution meeting, see resolution process, or the hearing officer gives permission, which may only be given at any time, but not later than 5 calendar days before the hearing begins. Connecticut State Department of Education, 18 Procedural Safeguards Notice Required, under IDEA Part B. If the complaining party, you or the school district, makes changes to the due process hearing request, the timelines for the resolution meeting, within 15 calendar days of the school district receiving the request, and the time period for resolution, within 30 calendar days of the school district receiving the complaint, start again on the date the amended hearing request is filed with the school district. School district response to a due process hearing request. If the school district has not sent prior written notice to you, see prior written notice, regarding the issues noted in your request for hearing, the school district must, within 10 calendar days of receiving your request for hearing, send you a response that includes the following information. 1. An explanation of why the school district proposed to or refused to take the action raised in the due process complaint. 2. A description of other options your child's PPT talked about and the reasons those options were rejected. 3. A description of each evaluation procedure, assessment, record, or report that the school district used as a basis for the proposed or refused action. 4. A description of the other factors that were relevant to the school district's proposed or refused action. Providing this information does not prevent the school district from claiming that the content of your due process hearing request was insufficient. Except as provided immediately above, the party receiving a due process hearing request must, within 10 calendar days of receiving the due process hearing request, send to the other party a response that specifically addresses the issues in the due process hearing request. Model Forms 34 CFR Taikrai 300.509. The CSDE has developed a model form to help you file a due process hearing request and to help you and other parties to file a state administrative complaint. However, the school district or the CSDE may not require the use of these model forms. You may use the model form or another appropriate form so long as it contains the required information for filing for a due process hearing request or state administrative complaint. The model forms are available below or can be located at the Bureau of Special Education's Legal and Due Process page. Administrative Complaint Hearing and Advisory Opinion. Mediation. Connecticut State Department of Education, 19 Procedural Safeguards Notice Required under IDA Part B Due Process Hearing Procedures. 34 CFR 300.511, CGS TER 1076H, RSCA Parif 1076H-1 through 1076H-18 General. Upon receipt of a written request for a hearing, the CSDE Bureau of Special Education Due Process Unit will appoint an impartial hearing officer and notify both parties and the hearing officer in writing of the appointment. Before the start of the hearing, you and the school district will take part in a telephone call with the hearing officer. This is called a pre-hearing conference. During the call, you and the school district will simplify or clarify the issues in dispute. The hearing officer may also establish dates for the completion of each party's evidence and review the possibility of a settlement of the case. Impartial hearing officer. The hearing will be held by a hearing officer who must not be an employee of the CSDE or the school district where the child goes to school, or the school district responsible for the child's education, must not have a personal or professional interest that would get in the way of his or her being fair in the hearing, must be knowledgeable about and understand the federal, IDEA, and state special education laws and regulations and the way these laws are understood by federal and state courts, and must have the knowledge and ability to conduct hearings and be able to write decisions in accordance with appropriate standard legal practice. A person who would be a hearing officer is not an employee solely because he or she is paid by the CSDE to act as a hearing officer. The CSDE Due Process Unit shall keep a list of the persons who serve as hearing officers. This list shall state the qualifications of each of those persons and can be located at the Bureau of Special Education's Legal and Due Process page. Subject matter of due process hearing. The party, you or the school district, that files the due process hearing request may not raise issues at the due process hearing that were not addressed in the due process hearing request, unless the other party agrees. Timeline for requesting a hearing. Exception. You or the school district must request a due process hearing within 2 years of the date you or the school district knew or should have known about the issue addressed in the hearing request. This timeline does not apply to you if you could not file the due process hearing request because the school district specifically misrepresented that it had resolved the problem or issue that you are raising in your hearing request, or the school district withheld information from you that it was required to provide to you under Part B of the IDEA. Connecticut State Department of Education, 20 Procedural Safeguards Notice required under IDEA Part B hearing rights. 34 CFR 300-512, RCSA 1076H-11 General. You have the right to represent yourself at a due process hearing. In addition, any party to a due process hearing, including a hearing relating to disciplinary procedures, has the right to be accompanied and advised by an attorney or persons with special knowledge or training about the problems of children with disabilities. Be represented at the due process hearing by an attorney. Present evidence, question, confront, cross-examine, and require the attendance of witnesses. Prohibit the introduction of any evidence at the hearing that had not been given to that party at least 5 business days before the hearing. Evaluations that have been completed by that date and recommendations from the evaluations that one intends to use at the hearing shall be given at least 5 business days before the hearing. Obtain a written, or at your option, electronic, word-for-word record of the hearing, and obtain written, or at your option, electronic findings of fact and decisions. Parental rights at hearings 1. You have the right to have your child at the hearing and to open the hearing to the public. 2. You have the right to be provided with the record of the hearing at no cost. 3. You have the right to represent yourself at a due process hearing. Additional disclosure of information. The hearing officer may prevent you or the school district from giving any evidence at the hearing without the permission of the other party if you or the school district fails to meet the above timeline regarding the submission of evidence. At least 5 business days prior to a due process hearing, you and the school district must disclose to each other all evaluations completed by that date and recommendations based on those evaluations that you or the school district intend to use at the hearing. A hearing officer may prevent any party that fails to comply with this requirement from introducing the relevant evaluation or recommendation at the hearing without the consent of the other party. Connecticut State Department of Education, 21 Procedural Safeguards Notice required under IDEA Part B Resolution Process 34 CFR 300.51 Resolution Meeting. Within 15 calendar days of receiving your due process hearing request and before the due process hearing begins, the school district must convene a meeting with you and the relevant members of the PPT who have specific knowledge of the facts identified in your due process hearing request. You and the school district determine the relevant members of the PPT to attend the meeting. The school district must have a person at the meeting who has the authority to make a decision for the school district. The school district may not bring an attorney unless you bring an attorney. The purpose of the resolution meeting is for you to discuss your due process hearing request and the facts that form the basis of the due process hearing request, so that the school district has the opportunity to resolve the dispute. The resolution meeting does not have to be held if you and the school district agree in writing not to have the resolution meeting, or you and the school district agree to use mediation. Resolution period. If the school district has not resolved the due process hearing request to your satisfaction within 30 calendar days of receiving the due process hearing request, during the time period for the resolution process, the due process hearing may begin except as noted below. Adjustments to the 30 calendar day resolution period. The 45 calendar day timeline for issuing a final due process hearing decision begins at the expiration of the 30 calendar day resolution period, with certain exceptions for adjustments made to the 30 calendar day resolution period, as described below. Unless you and the school district both agree not to have the resolution meeting or to use mediation, your failure to participate in the resolution meeting will delay the timelines for the resolution process and the due process hearing until the resolution meeting is held. If, after making reasonable efforts and documenting those efforts, the school district is not able to obtain your participation in the resolution meeting, the school district may, at the end of the 30 calendar day resolution period, ask the hearing officer to dismiss your due process complaint. Documentation of the school district's efforts to obtain your participation must include a record of the school district's attempt to arrange a mutually agreed upon time and place, such as detailed records of telephone calls made or attempted and the results of those calls, and copies of correspondence sent to you and any responses received. Connecticut State Department of Education 22 Procedural Safeguards Notice required under IDEA Part B. If the school district fails to hold the resolution meeting within 15 calendar days of receiving your due process complaint, or fails to participate in the resolution meeting, you may ask the hearing officer to begin the 45 calendar day due process hearing timeline. Adjustments to the 30 calendar day resolution period. The 30 calendar day resolution period may be adjusted. The 45 calendar day timeline for the hearing will start the day after one of the following events. 1. You and the school district agree in writing not to hold the resolution meeting. After the mediation or resolution meeting starts, but before the end of the 30 calendar day resolution period, you and the school district agree in writing that no agreement is possible. 3. If you and the school district agree in writing to continue the mediation at the end of the 30 calendar day resolution period, but later you or the school district withdraws from the mediation process. Written settlement agreement. If at the resolution meeting you and the school district resolve the issues, you and the school district must enter into a legally binding agreement that is signed by you and a person from the school district who has the authority to make the agreement, and enforceable in any state court of competent jurisdiction, a state court that has authority to hear this type of case, or in a district court of the United States agreement review period. You or the school district will have 3 business days from the signing of the agreement to change your minds and not have to go along with the agreement. Connecticut State Department of Education 23 Procedural Safeguards Notice required under IDEA Part B Mediation. 34 CFR 300.56, RCSA 1076H-5. Mediation is a way to settle a dispute when you and the school district disagree on the identification of a child, the evaluation of a child, the educational placement of a child, or any other matter related to provision of FAPE to a child. Mediation is voluntary. This means that you and the school district have a choice to use mediation to resolve the dispute. Neither you nor the school district is required to agree to use mediation. The mediation cannot be used to deny or delay your right to a hearing, or deny any other rights that you have under the state or federal special education laws. Before filing a state administrative complaint, or before asking for a due process hearing, or anytime after filing a due process hearing request, or during the due process hearing, you and the school district may ask for mediation by sending a letter to Connecticut State Department of Education, Bureau of Special Education, Due Process Unit, P.O. Box 22119, Hartford, CT 061452219, fax 860-713-7153. The request for mediation may also be submitted electronically to dueprocess.sde@ct.gov. The Due Process Unit has a list of mediators and will assign a mediator from a rotating list who is trained in mediation, does not have a conflict of interest, is knowledgeable about the special education laws, and does not provide direct services to the child who is the subject of the mediation. The mediator will try to help settle the concerns of you and the school district. The mediation will be held in a timely manner, and in a place that is close for you and the school district staff. The CSDE pays for the cost of the mediation process. If you and the school district reach agreement on the issues, what you have agreed to will be put in writing and will be signed by you and the person from the school district who has the authority to sign the agreement. The mediation agreement shall state the discussions that occurred during the mediation will remain confidential and may not be used as evidence in any subsequent due process hearing or court action that may follow the mediation. The mediation agreement is enforceable in any state court or in federal district court with jurisdiction over these matters. Connecticut State Department of Education, 24 Procedural Safeguards Notice required under IDEA Part B, Advisory Opinion Process, RCSA, Parahen 76H-6. Prior to a due process hearing being convened, Section 1076H6 of the Regulations of Connecticut State Agencies allows you and the school district to request a one-day hearing through the advisory opinion process, which may be granted at the discretion of the CSDE. After a hearing has been requested, you and the school district may agree to the advisory opinion process by sending a letter or filling out the advisory opinion process form and sending it to Connecticut State Department of Education, Bureau of Special Education, Due Process Unit, P.O. Box 2219, Hartford, CT 6145-2219. Fax 860-713-7153. The request for an advisory opinion may also be submitted electronically to dueprocess.sde@ct.gov. The advisory opinion process allows you and the school district to state your positions in a brief manner to a hearing officer in one day. There are limits on the amount of time you and the school district have to present your positions and the number of witnesses you and the school district may present. After listening to the arguments made by you and the school district, the hearing officer will tell you and the school district how the hearing officer thinks the issues would be decided if the parent and the school district went on to a full hearing. The hearing officer who does the advisory opinion is not the same hearing officer who would hold the full hearing. You and the school district do not have to accept the view of the hearing officer who gives the advisory opinion. You and the school district may go on to a full hearing if the issues are not settled by receiving an advisory opinion. Connecticut State Department of Education 25 Procedural Safeguards Notice required under IDEA Part B Hearing Decisions, 34 CFR 300.513, RCSA 1076H16, Decision of the Hearing Officer. A decision made by the hearing officer on whether your child received a free appropriate public education must be based on evidence and arguments that directly relate to FAPE, that is, on legal rights and principles. In matters alleging a procedural violation, a hearing officer may find that your child did not receive FAPE only if the procedural violations interfered with your child's right to receive FAPE, significantly interfered with your opportunity to participate in the decision-making process regarding the provision of FAPE to your child, or caused your child to be deprived of an educational benefit. None of the provisions described above can be interpreted to prevent a hearing officer from ordering a school district to follow the requirements in the Procedural Safeguards section of the federal regulations under Part B of the IDEA. 34 CFR 300.50 through 300.536, even if the hearing officer found that your child was not kept from receiving FAPE. Separate request for a due process hearing. Nothing in the Procedural Safeguards section of the federal regulations under Part B of the IDEA, 34 CFR 300.50 through 300.563, can be interpreted to prevent you from filing a separate due process hearing request on an issue separate from a due process hearing request already filed. Findings and decision, convenience of hearings, State Advisory Council to receive copy of decision. Decisions to be available to the public within 45 calendar days of the start of the hearing timeline. A final decision in the hearing shall be reached, and a copy of the decision shall be mailed to each of the parties by the CSDEBSE. The hearing officer may allow extra time beyond the 45 calendar day timeline when asked for by you or the school district. The CSDE shall, After taking out any data that would make the identity of the child easily known, send the written findings of fact and decisions to the State Advisory Council for Special Education and make them available to the general public. Final decisions are available on the CSDE website. Connecticut State Department of Education 26 Procedural Safeguards Notice Required under IDA Part B Appeals. Finality of the decision, appeal, impartial review. 34 CFR 300.54. RCSA 1076H-16, finality of the hearing decision. A decision made in a due process hearing, including a hearing relating to disciplinary procedures, is final, except that any party involved in the hearing, you or the school district, may appeal the decision by bringing a civil action to either state court of competent jurisdiction or federal district court. Civil action, including the time period in which to file those actions, 34 CFR Part 300.516, General. Any party, you or the school district, who does not agree with the findings and decision in the due process hearing, including a hearing relating to disciplinary procedures, has the right to bring a civil action with respect to the matter that was the subject of the due process hearing. The action may be brought in state superior court or in a federal district court of the United States without regard to the amount in dispute. Time limitations for filing on appeal. The party, you, or the school district bringing the appeal has 45 calendar days from the date the decision is mailed to file a civil action. Additional procedures. If you or the school district appeal the decision of the hearing officer to either the state superior court or the federal district court, the court receives the records of the hearing, hears additional evidence when asked by you or the school district, and bases its decision on the greater amount, preponderance, of evidence, and grants the relief that the court determines to be appropriate. Jurisdiction of district courts. The district courts of the United States have the authority to rule on actions brought under Part B of the IDEA without regard to the amount of money in dispute. Connecticut State Department of Education 27 Procedural Safeguards Notice Required under IDEA Part B Rule of Construction. Nothing in Part B of the IDEA restricts or limits the rights, procedures, and remedies available under the U.S. Constitution, the Americans with Disabilities Act of 1990, Title V of the Rehabilitation Act of 1973, Section 504, or other federal laws protecting the rights of children with disabilities, except that before the filing of a civil action under these laws, seeking relief that is also available under Part B of the IDEA, the due process procedures described above must be exhausted to the same extent as would be required if the party filed the action under Part B of the IDEA. This means that you may have remedies available under other laws that overlap with those available under the IDEA. But in general, to obtain relief under those other laws, you must first use the available administrative remedies under the IDEA. For example, the due process hearing, resolution process, including the resolution meeting, if not waived, and impartial due process hearing procedures, before going directly into court. Connecticut State Department of Education 28 Procedural Safeguards Notice Required under IDEA Part B. The child's placement while the due process hearing is pending, 34 CFR 300.518, RCSA 1076H-17. Except as provided below, and in certain circumstances, as explained in the section following on disciplining a child with a disability, when a due process hearing has been requested, your child must stay where the child is placed when the due process hearing request is filed with the same services your child was getting. Your child must stay in this program until the matter is settled, unless you and the school district agree to change the school program. If a hearing officer agrees with you that a change to your child's school program is appropriate, the order of the hearing officer must be carried out, even if a court review, see appeals, has been asked for. If your child is to enter public school for the first time, your child, with your consent, must be able to go to school until the completion of all proceedings and must be placed in the regular public school program until the completion of all proceedings. If your child turns 3 years of age and is coming from a Birth to 3 program, the school district is not required to provide the Birth to 3 services that your child had been receiving. If your child is found to be eligible for special education services and you consent for your child to receive services for the first time, the school district must provide the services that are not in dispute between you and the school district. If the school district or you ask for a due process hearing after your child has been placed in an interim alternative educational setting, IAES, for disciplinary reasons for not more than 45 school days by the school district or by a hearing officer described in further detail under the upcoming subsections, special circumstances, placement in an IAES, and appeal. Expedited due process hearing for disciplinary matters. Your child must stay in the IAES until the hearing officer decides differently or until the end of the specified time, which shall not be more than 45 school days. Whichever comes first, unless you and the school district agree to change the school program. If the school district wants to change your child's program after the specified time in the IAES is up and asks for a hearing, your child would return to the school program that your child was in before being placed in the IAES while the due process hearing is held. Connecticut State Department of Education 29 Procedural Safeguards Notice required under IDEA Part B Attorney's Fees 30 CF Park 300.57 General. In any action or proceeding brought under Part B of the IDEA, the court in its discretion may award reasonable attorney's fees as part of the costs to you. If you prevail, the case is decided in your favor, either in whole or in part. In any action or proceeding brought under Part B of the IDEA, the court, in its discretion, may order you or your attorney to pay reasonable attorney's fees as part of the costs to the school district or the CSDE, if the CSDE is a party to the case, if they prevail in the case. If your attorney files a request for a hearing or review by the court that is needless, is without good reason, or is without a proper basis, frivolous, unreasonable, or without foundation, or continues to litigate after it is clear that the matter is needless, is without good reason, or is without a proper basis, or in any action or proceeding brought under Part B of the IDEA, the court in its discretion may order your attorney or you to pay reasonable attorney's fees as part of the costs to the school district or the CSDE if your request for a due process hearing or later court case was made for any improper purpose, such as to harass, to cause unnecessary delay, or needlessly increase the cost of the hearing or the court review. Award of fees. A court awards reasonable attorney's fees according to the following. The amount of attorney's fees that is decided is based on rates common in the area in which the hearing or court review arose for the kind and quality of services provided. No extra means may be used in figuring the fees ordered. Attorneys' fees may not be ordered, and related costs may not be returned to you in any hearing or court review for services provided after the time of a written offer to you to settle the matter if the offer is made within the time allowed by federal rule, or in the case of a hearing, at any time more than 10 calendar days before the hearing begins. The offer is not accepted within 10 calendar days, and the court finds that the relief finally given to you is not more than the offer to settle the matter. An order for the return of attorney's fees may be made to you if you succeed with your case, if you had good reason for not taking the offer made by the school district to settle the matter, and if the final decision was not more favorable to you. An award of attorney's fees may not be ordered for any meeting of the PPT unless the PPT meeting is held as a result of a hearing or a court review, a mediation, see mediation, or Connecticut State Department of Education 30 Procedural Safeguards Notice required under IDEA Part B, the resolution meeting, see resolution meeting. The court may lower attorney's fees whenever it finds that you or your attorney during the hearing or the court review unreasonably delayed a final resolution of the dispute. The amount of the attorney's fees goes beyond, without good reason, the hourly rate common in the area for the same type of services by attorneys who compare in skill, reputation, and training. The time spent and legal services provided were excessive considering the type of hearing or court review, or the attorney representing you did not give to the school district the required information when requesting the hearing when submitting the due process complaint. However, the court may not lower attorney's fees if the court finds that the school district or the state unreasonably delayed the final resolution of the hearing or the court review, or the procedural safeguards under Part B of the IDEA were violated. Connecticut State Department of Education. 31. Procedural safeguards notice required under IDEA Part B procedures for disciplining children with disabilities. 34. CFR Part 300.530 Authority of School Personnel, case-by-case determination. School personnel may consider any special concerns, unique circumstances, on a case-by-case basis when determining whether a change of placement, made in accordance with the following requirements related to discipline, is appropriate for a child with a disability who violates a code of school conduct. General. To the extent that a school district also takes such action for children without disabilities, the school district may remove a child who violates a school rule from the current program to an interim alternative educational setting, IAES, another setting, or suspension for not more than 10 school days in a row, or for more than 10 school days in a school year, and for additional removals of not more than 10 school days in a row in the same school year for separate incidents of misconduct, provided the removals do not result in a change in placement. See change in placement below. A school district is required to provide services to a child who has been removed from his or her current placement for 10 school days or fewer in the same school year if the school district provides services to a child without a disability who has been similarly removed. Once a child with a disability has been removed from his or her current placement for a total of 10 school days in the same school year, the school district must, during any subsequent days of removal in that school year, provide services to the extent required below. See services during removal below. Additional authority. If the behavior that violated the code of school conduct was not a manifestation of the child's disability, see manifestation determination below, and the disciplinary change of placement would exceed 10 school days in a row, school personnel may apply the disciplinary procedures to that child with a disability in the same manner and for the same duration as it would to children without disabilities, except that the school must provide services to that child as described below under services during removal. The child's PPT determines the IAES for such services. Change in placement because of disciplinary removals. 34 CFR 300.530, 34 CFR 300.536. A change in placement occurs if the removal is for more than 10 school days in a row, or the removals make up a pattern because other removals total more than 10 school days in a school year. Connecticut State Department of Education. 32 Procedural safeguard is required under IDEA Part B. A child's behavior is very much like the child's behavior in previous incidents that resulted in other removals, and other factors such as the length of each removal, the total amount of time the child has been removed, and the closeness in time of the removals to one another. The school district shall determine on a case-by-case basis whether a pattern of removals is a change in placement. Services during removal. After a child has been removed from his or her school program for 10 school days in the same school year, and the current removal is not for more than 10 school days in a row and is not a change in placement, the school staff, along with at least one of the child's teachers, shall determine the extent to which services are needed to enable the child to continue in the general education coursework, although in another setting, and to progress toward meeting the goals of the IEP. The student shall receive, as appropriate, a functional behavioral assessment, FBA, and behavior intervention services and modifications that are designed to address the behavior violation so that it does not happen again. If the removal is a change of placement, the child's PPT determines the appropriate services to enable the child to continue to participate in the general education curriculum, although in another setting, that may be an interim alternative educational setting, and to progress toward meeting the goals set out in the child's IEP. A child with a disability who is removed from the child's current placement for more than 10 school days, and the child's behavior is not a manifestation of the child's disability, see manifestation determination below. Or who is removed under special circumstances, see special circumstances placement in an IAS next page, must, 1. Continue to receive educational services. Have available a free, appropriate public education so as to enable the child to continue to participate in the general education curriculum, although in another setting, that may be an interim alternative educational setting, and to progress toward meeting the goals set out in the child's IEP. 2. Receive as appropriate a functional behavioral assessment and behavioral intervention services and modifications, which are designed to address the behavior violation so that it does not happen again. Manifestation determination. Within 10 school days of any decision to change a child's placement for more than 10 school days because the child violated a school rule, the school district with the parent and relevant members of the PPT to be determined by the parent and the school district shall review all relevant information in the child's school file, including the IEP, teacher observations, and any relevant information provided by the parent to determine if the behavior in question was caused by or was directly or to a large extent related to the child's disability, or the direct result of the school district's failure to implement the IEP. Connecticut State Department of Education, 33 Procedural Safeguards Notice required under IDEA Part B. If the school district with the parent and relevant members of the PPT determines that either of the above applies to the child, the behavior in question shall be determined to be a manifestation of the child's disability. This decision is known as the manifestation determination. Behavior was a manifestation of the child's disability. If the school district with the parent and relevant members of the PPT determines that the behavior in question was a direct result of the school's failure to implement the IEP, the school district must take immediate steps to remedy the deficiencies. If the school district with the parent and relevant members of the PPT decides the behavior in question was a manifestation of the child's disability, the PPT shall do the following as appropriate to the circumstances presented. 1. If the school district had not already conducted a functional behavior assessment, FBA, before the behavior in question occurred, conduct an FBA and put into effect a behavior intervention plan, a plan to improve the child's behavior so that behavior that resulted in the change of the child's program does not happen again. 2. If a BIP is already in place, the PPT will review the BIP and modify it as necessary to address the behavior in question. 3. Except as noted in the IAES section below, the school district shall return the child to the program that the child was in before being removed, unless the school district and the parent agree to a change in the child's placement as part of the revised BIP. Notification. On the date that a decision is made for a removal that would be a change in placement, the school district must notify the parent of that decision and provide the parent with a copy of the procedural safeguards notice required under IDEA Part B. Special circumstances. Placement in IAES. A school district may place a child in an IAES for not more than 45 school days without regard to the manifestation determination in cases where a child carries a weapon to school or has a weapon at school, on school grounds, or while at a school activity, knowingly has or uses illegal drugs, or sells or tries to buy a controlled substance while at school, on school grounds, or at a school activity, or has caused serious bodily injury upon another person while at school, on school grounds, or at a school activity. When the school district orders a child to an IAES for not more than 45 school days, the school district must hold a PPT meeting to determine the IAES. Definitions. Controlled substance means a drug or other substance identified under Schedules IL, IV, or V in Section 202C of the Controlled Substances Act, 21 U.S.C. 812C. Connecticut State Department of Education, 34 Procedural Safeguards Notice required under IDEA Part B. Illegal drug means a controlled substance, but does not include a controlled substance that is legally possessed or used under the supervision of a licensed healthcare professional, or that is legally possessed or used under any other authority under that act or under any other provisions of federal law. Serious bodily injury has the meaning given to the term serious bodily injury under paragraph 3 of subsection H of Section 1365 of Title 18 United States Code. Weapon has the meaning given to the term dangerous weapon under paragraph 2 of the first subsection G of Section 1365 of Title 18 United States Code. Appeal, expedited due process hearing for disciplinary matters, 34 CFR 30532, RCSA Stenged 76H General. You may file a due process complaint to request a due process hearing if you disagree with any decision regarding placement made under these discipline provisions or the manifestation determination described above. The school district may file a due process complaint to request a due process hearing if it believes that maintaining the current placement of your child is substantially likely to result in injury to your child or to others. RCSA 1076H, Authority of the Hearing Officer. A hearing officer who meets the requirements of the impartial hearing officer described under the heading Due Process Procedures must conduct the due process hearing and make a decision. The hearing officer may return your child with a disability to the placement from which your child was removed if the hearing officer determines that the removal was a violation of the requirements described under the section above, authority of school personnel, or that your child's behavior was a manifestation of your child's disability, or order a change of placement of your child with a disability to an appropriate IAES for not more than 45 school days if the hearing officer determines that maintaining the current placement of your child is substantially likely to result in injury to your child or to others. These hearing procedures may be repeated if the school district believes that returning your child to the original placement is substantially likely to result in injury to your child or to others. Whenever you or a school district files a due process complaint to request such a hearing must be held that meets the requirements described under the heading Due Process Procedures. Filing for a due process hearing, except as follows. 1. The CSDE must arrange for an expedited due process hearing, which must occur within 20 school days of the date the hearing is requested, and must result in a determination within 10 school days after the hearing. Connecticut State Department of Education, 35 Procedural Safeguards Notice required under IDEA Part B. Unless you and the school district agree in writing to waive the meeting or agree to use mediation, a resolution meeting must occur within 7 calendar days of receiving notice of the due process complaint. The hearing may proceed unless the matter has been resolved to the satisfaction of both parties within 15 calendar days of receipt of the due process complaint. The CSDE will arrange for an expedited hearing when a hearing is asked for as follows. The school district thinks that keeping your child in the current school program is to a large extent likely to result in injury to your child or to others, and the school district wants to put your child in an interim alternative educational setting, IAES, for not more than 45 school days. Your child is placed in an IAES, and the school district wants to change your child's school program at the end of the IAES because the school district believes it is a danger for your child or others for your child to be in the school program that your child was in before being placed in the IAES. And the school district asks for an expedited hearing. This hearing procedure may be repeated. You challenge an alleged change of placement and believe your child has been kept out of school for more than 10 days in a row or for more than 10 days in a school year without the school district. Following the proper steps, you do not agree with the school district placing your child in an IAES for a violation of the school district code of conduct concerning weapons, drugs, or dangerousness, or you do not agree with the manifestation determination. Upon a request for a hearing for any of the matters noted in this section, the hearing shall occur within 20 school days of the date the hearing request is filed and shall result in a decision within 10 school days after the hearing. Each party to a hearing has the right to keep any evidence from being presented at the hearing that has not been given to the other party at least 5 business days before the hearing, and shall give to all other parties all evaluations completed to date and the recommendations from the evaluations that the party wants to use at the hearing at least 5 business days before the hearing. Connecticut State Department of Education, 36 Procedural safeguards notice required under IDEA Part B protections for children not yet eligible for special education and related services. 34 CFR 3300.534 General. If your child has not been determined eligible for special education and related services and violates a code of student conduct, but the school district had knowledge, as determined below, before the behavior that brought about the disciplinary action occurred, that your child was a child with a disability, then your child may assert any of the protections described in this notice. Basis of knowledge for disciplinary matters. A school district will be deemed to have knowledge that your child is a child with a disability if, before the behavior that brought about the disciplinary action occurred, you expressed concern in writing to supervisory or administrative personnel of the appropriate educational agency or to your child's teacher that your child is in need of special education and related services. You requested an evaluation related to eligibility for special education and related services under Part B of the IDEA, or your child's teacher or other school district personnel expressed specific concerns about a pattern of behavior demonstrated by your child directly to the school district's director of special education or to other supervisory personnel of the school district. Exception. A school district would not be deemed to have such knowledge if you have not allowed an evaluation of your child or have refused special education services, or your child has been evaluated and determined to not be a child with a disability under Part B of the IDEA. Conditions that apply if there is no basis of knowledge. If prior to taking disciplinary measures against your child, a school district does not have knowledge that your child is a child with a disability, as described above, under the subheadings Basis of Knowledge for Disciplinary Matters and Exception, your child may be subjected to the disciplinary measures that are applied to children without disabilities who engage in comparable behaviors. However, if a request is made for an evaluation of your child during the time period in which your child is subjected to disciplinary measures, the evaluation must be conducted in an expedited manner. Until the evaluation is completed, your child remains in the educational placement determined by school authorities, which can include suspension or expulsion without educational services. Connecticut State Department of Education, 37 Procedural safeguards notice required under IDEA Part B. If your child is determined to be a child with a disability, taking into consideration information from the evaluation conducted by the school district, and information provided by you, the school district must provide special education and related services in accordance with Part B of the IDEA, including the disciplinary requirements described above. Connecticut State Department of Education, 38 Procedural safeguards notice required under IDEA Part B, referral to and action by law enforcement and judicial authorities. 34 CFR 300.535, Part B of the IDEA does not prohibit an agency from reporting a crime committed by a child with a disability to appropriate authorities, or prevent state law enforcement and judicial authorities from exercising their responsibilities with regard to the application of federal and state law to crimes committed by a child with a disability. Transmittal of records. If a school district reports a crime committed by a child with a disability, the school district must ensure that copies of the child's special education and disciplinary records are transmitted for consideration by the authorities to whom the agency reports the crime, and may transmit copies of the child's special education and disciplinary records only to the extent permitted by FERPA. Connecticut State Department of Education, 39 Procedural safeguards notice required under IDEA Part B, requirements for unilateral placement by parents of children in private schools. 34 CFR 300.148, General Part B of the IDEA does not require a school district to pay for the cost of education, including special education and related services, of your child with a disability at a private school or facility if the school district made FAPE available to your child and you choose to place the child in a private school or facility. However, the school district where the private school is located must include your child in the population whose needs are addressed under the Part B provisions regarding children who have been placed by their parents in a private school under 34 CFR Parster 300.131 through 300.144. Reimbursement for private school placement. If your child had previously received special education and related services under the authority of a school district, and you choose to enroll your child in a private preschool, elementary school, or secondary school without the consent of or referral by the school district, a court or a hearing officer may require the school district to reimburse you for the cost of that enrollment if it is decided that 1. The school district had not made available a FAPE that could meet your child's educational needs in a timely manner before you enrolled your child in the private school. 2. The private school program for your child meets your child's educational needs. The private school placement is appropriate. The private school program provided to your child may be found to be an appropriate program for your child by a hearing officer or a court, even if the private school does not meet the state standards that apply to the education provided by the school district. Limitation on reimbursement. The reimbursement of the costs for the private school may be denied or reduced if at the last PPT meeting that you attended before taking your child out of the public schools, you did not tell the PPT of not wanting the placement offered by the school district, state the concerns about the placement offered by the school district, and state the intent to enroll your child in a private school at public expense, or if at least 10 business days, including any holidays that occur on a business day, before taking your child out of the public school, you did not give notice in writing to the school district of not wanting the placement offered by the school district, state the concerns about the placement offered by the school district, and state the intent to enroll your child in a private school at public expense, or Connecticut State Department of Education 40 Procedural Safeguards Notice Required under IDEA Part B if before you took your child out of the public school, the school district told you in writing of its intent to evaluate your child, giving the purpose of the evaluation, and you did not make your child available for evaluation, or upon a court deciding that you did not act reasonably. The reimbursement of the cost of the unilateral placement shall not be reduced or denied because the parent did not tell the school, because the school district kept you from giving notice as noted above, you had not received notice from the school district that you had to tell the school district as noted above before putting your child in the private school if you wanted to get the school district to return the costs of the private school, or having to tell the PPT as noted above would likely result in physical harm to the child and may, in the finding of the hearing officer or the court, not be reduced or denied because you did not tell the school district because you cannot read and write in English. Or having to tell the PPT as noted above would likely result in serious emotional harm to your child. Connecticut State Department of Education 41 Connecticut State Department of Education